speeding down a highway in Burnett County and throwing things out of the car to try and evade and flee the officers. The officer could swerve and hit a pedestrian, could hit a different vehicle, could hit a house. The officer could die. Innocent people could have died. But you are letting your internal demons destroy you. State of Wisconsin versus Joseph, also known as Josie Smith. Josie, you may come up here and have a seat. We're set for a sentencing portion of this case. There's been an extensive, significant delay in this matter from the beginning to finally the end. Josie, there were multiple times in where I would define it as you absconded. You failed to appear for court for very lengthy periods of time. A lot of money had been forfeited to the county, which would be at your expense because it was a lot of cash. I'm not even sure if we have any cash still posted, but the clerk will let me know during the process of this hearing. You pled guilty way back on November 20th, 2025. The court ordered a pre-sentence investigation report for those two felonies. One is a second-degree recklessly endangering safety, Class G felony, and the other felony is vehicle operator, flee or elude an officer. The court has received and reviewed the pre-sentence investigation report. Again, that took a lot of time and effort due to the fact that it was ordered, they weren't able to get a hold of you, you didn't contact them, you absconded, and that happened at least on 2 occasions that I can recall. Josie, did your attorney go over that document, this one right here, this big thick document with you thoroughly?
Yes.
And you could not find any material errors that would need to be corrected?
No.
Okay. All right. So I'm going to start with you, Mr. Schmidt, sentencing recommendation and argument.
Thank you. State's going to be recommending the court follow the Department of Corrections recommendation. The court should order 1.5 in, 2 out on the fleeing, should order 3 in, 4 out on the reckless. Those counts should be concurrent to each other because they were part and parcel of the same action or series of acts on the same day. They described the same conduct. They should be consecutive to any other sentence in Wisconsin or Minnesota because they are distinct acts in a distinct state. I start first with explaining why probation should be rejected. First off, this is Smith committing their 3rd fleeing offense. They have 1 prior criminal conviction for it and 1 prior adjudication of delinquency for it. This offense was committed while on supervision for one of the fleeing offenses. Probation is a consequence for a crime that you're already on probation for and you do it again it's nonsensical. That is the clearest sign that probation unduly depreciates the seriousness of the offense. Furthermore, Smith's history clearly demonstrates that they're just not amenable to supervision at all. At age 25, Smith has 10 prior criminal convictions, counting these 2 today, and 9 prior juvenile adjudications for crime. That's 19 convictions or adjudications over only 13 years. When you go down and read through that sentencing, what do you see? In the criminal cases, you see probation ordered every single time, 8 times convicted prior to today. Smith was given 8 orders of probation. Smith has persuaded adult courts to place them on probation every single time. 8 times Smith has been ordered, to work with agents, to deal with substance abuse, to deal with mental health, to deal with cognitive issues. 8 times it's failed. CCAP and MCRO are useful in figuring out why. And that's because Smith simply doesn't participate unless they're physically forced to. MCRO and CCAP show countless failed court appearances while the cases are ongoing and probation violations once they've concluded. Smith's own stated reason in our case for fleeing the police was to avoid those consequences. Smith had 3 different Minnesota warrants out for her arrest when this fleeing happened. In our own case, even, it took 4 warrants across 3 years to force Smith here to this table at this moment. The court gave Smith a big leap of faith when it allowed her to stay out and go to that treatment facility while waiting for the PSI. And Smith demonstrated why she's not amenable to supervision when she didn't come back when she absconded. As a result, probation is not appropriate for this offender. There's no reason to think that she will comply when there's a decade of history telling us otherwise. Smith needs treatment, and this needs to happen in a confined setting. I find it strange that Smith related to the PSI writer that they didn't believe incarceration is effective at changing people's behavior because, like I said, Smith's effectively been on some form of supervision for 13 years, going way back into her childhood. She's not been given incarceration. So to conclude it's not effective when what you're asking for has itself not been effective doesn't make a ton of sense. It should be no wonder that Smith has continued unabated in her behavior because she's simply not been held accountable. The only time she's gotten incarceration, it's been as a revocation or a DOC action for noncompliance. The PSI talks about some of Smith's challenges, her criminogenic needs. Smith has a family that has a lot of members who have been involved in criminal activity. She talks about that in her own, how that's affected her own struggles in the PSI. She grew up with said family and said that they made drugs available to her, causing early life addiction issues that continue to this day. She has mental health struggles. At 25, she's seemingly not ever worked a job ever. These are all things that can and should be addressed when considering the character of the offender. These are obvious things that need to be dealt with to deal with the idle hands issue that I think is a cause of a lot of this crime. Those issues should be dealt with though in prison though, because prison does have resources that Smith hasn't tried. Being on supervision one way or another for 13 years in Minnesota, where they have far more programs than us, she's exhausted everything. Even beyond that, though, there's profound need for deterrence and punishment in this case. To me, the number one thing I look at when I'm reading a PSI is the offender's version of their prior history. What a person thinks about what they've done in the past and how they talk about it now in the present tells you a lot about them. It tells you what is important enough to them to remember that they talk about later, how it affected them. This tells you about cognition. It tells you about criminal thinking. It tells you about consciousness of guilt. It tells you how they're going to think about this case in 5 years and 10 years. To the defendant's credit, she does appear to take responsibility for, without making excuses of her adult criminal history. That's more than we can say for a lot of the people that come before this court. However, the defendant claims they don't remember any of the incidents that happened when they were a juvenile. I find this concerning for two reasons. One, that juvenile record was not that long ago. This defendant's only 25 years old. It was not, it was too long ago was not a viable excuse for not remembering. However, the main reason I'm really concerned about this is because Smith's juvenile record, I'm sure the court's noticed, is categorically different from her adult record in that the juvenile record is mostly victim cases. It's assaults, it's thefts, it's crime damage, it's arson, offenses where those should be the ones you do remember. Those are the ones you hurt somebody either physically or financially or emotionally. Those are the ones where if you have empathy and consciousness of guilt, you relate back, wow, I did this terrible thing to that person, that hurts, I want to change who I am as a person. Not these fleeings or a simple possession or something like that. There's indication in multiple places in the PSI that Smith would want to address issues and change herself, but none of those really seem to be in connection with remorse or feeling bad. They seem to be connected to improving her own experience in her own life. Looking at page 10 in the PSI, the defendant says she expresses remorse, but only talks about wanting to achieve better outcomes in her own life in terms of rehabilitation. To that end, what is left when you have a person who's been supervised constantly through various forms of adult and child supervision over a decade, and it continues to fail? You do incarceration. That's what Minnesota finally did after many years in their most recent probation revocations. According to the PSI, if the court orders incarceration up front in this case, it'd be the first time ever that any court has done so in Smith's life. The only time she's ever gotten any sentences, like I said, been on the revocation or been on some sort of a hold while waiting for treatment or something like that. It'll only be the second time she's ever been ordered to prison. Unfortunate that Smith's been allowed to accumulate this kind of history in Minnesota. It would defy the sentencing factors in Wisconsin for a person to accumulate this many convictions and not get any incarceration. The McCleary-Gallion factors wouldn't allow it. these cases and what these convictions are for and the non-appearances all reflect a deep cognition issue that doesn't really get addressed in the defense sentencing memorandum at all. The defense sentencing memorandum really just talks about substance abuse and another issue, which I'll get to later. When treatment fails, when cognition is contaminated with what I kind of view in the PSI and the offender's version of, what happened and what to do next and what their goals are, it reads like me. It reads like somebody who isn't thinking about rejoining society for the purpose of helping others or feeling bad about the victims in their cases. To that end, that's why you need specific deterrence in cases like this. If you have an offender where those drivers that we usually rely upon for people to modify their behavior, empathy, consciousness of guilt, just feeling bad for your own actions is how I describe them. Those things you hope that get instilled in children at a young age. When those aren't happening, when they've already had all the attempts being on supervision, whether probation or court supervision, where they've had the option of going to treatment centers and having doctors and having agents with them to work on them to accomplish conditions of supervision. When that just fails over and over, that's when you need specific deterrence. That's when somebody isn't being motivated by the carrot, so they need to be motivated by the stick. And this is one of those cases. It also leads me to general deterrence and punishment. As I said previously, this is the third time that Smith has been either convicted criminally or adjudicated delinquent of fleeing. This fleeing involved throwing large objects into the road. One of them was described to me by Deputy Moe as like a metal ramp that sparked as it hit the road. Deputy Moe said that Smith threw it into the middle of the road and he had to make an abrupt movement to avoid it. If he had made a mistake, if he had not reacted quickly enough, one of these objects could have been struck by him or a different police officer at the speeds they were going. They could have died. That's the essence of what the reckless is. The reckless is creating a risk of death or great bodily harm. In this case, it was to a police officer just doing his job, trying to arrest Smith on a warrant that resulted from her own behavior, from not cooperating with supervision over in Minnesota. Smith admitted they were fleeing to avoid consequences and said she was high on meth while fleeing. That reckless conviction exists because the way Smith chose to go about fleeing this time was so much more dangerous than a typical fleeing we see in this county, than her past fleeings. Other people in the public have to be deterred, and quite frankly, the need for punishment is the reason why the recommendation here for a high-end fleeing sentence and a mid-range reckless sentence is being recommended, because the gravity of this offense, the way the reckless and the fleeing exacerbate each other, aggravate each other, is the reason why. This was a fleeing where the driver's speed was high. It varied between 40 and 69 miles per hour, where Smith would only slow down when throwing objects out of the vehicle. She blew stop signs. She crossed the center line. The vehicle only stopped because Smith disabled it herself while trying to get into the ditch to avoid a spike strip. Smith fled on foot afterwards after the vehicle wouldn't move anymore. Chase was over 10 miles. And it's a chase that endangered the deputies, as I described before, with the throwing of objects. This is not a young first-time offender who made a one-off mistake, who acted outside of character because of some underlying issue that heretofore has never been addressed before and is easily fixed. This is a 25-year-old person who has, despite 13 years of some help, some supervision, some court conditions, has continued to be a risk to the community, has been escalating in the risk to the community with this fleeing, who continues to ignore supervision and rules of courts. The courts have uniformly given Smith up to this point second, third, fourth, eighth chances, and now Smith is asking for a 19th one if you count the adjudications. McCleary Gallium factors demand more. The character of this offender is such that prison is necessary. Probation would unduly depreciate the seriousness of this offense, and the court should follow the recommendation of 1.5 in, 2 out on the fleeing, and 3 and 4 out on the reckless. Finally, there's one thing I do need to comment on. from the sentencing memorandum that I have a serious problem with. The defense sentencing memorandum makes arguments that use the defendant's gender as a basis. That memo argues prison is not safe for transgender people, that prison cannot allow Smith to navigate her gender identity. That I have two main responses. One, it is ridiculous and without evidence that the Wisconsin prison system cannot accommodate transgender people. It can and it does. The prisons are safe, probably safer than outside the prison because of all the supervision and control of inmates. This is a perpetuation of movie stereotypes that is wrong and harmful. Second, it's illegal for courts to consider gender as a sentencing factor in Wisconsin. It is categorically an improper sentencing factor, just like race or religion. The Supreme Court of Wisconsin explicitly held that gender cannot be considered in State v. Harris, 2010 WI 79. Any argument based upon Smith's gender should be disregarded by this court. It has no application to sentencing in Wisconsin. Thank you.
All right, thank you. Mr. Felicki, before I ask for your argument and recommendation, what is the jail credit?
Thank you, Your Honor. I have the following totals from a review of this file. It appears that initially Josie Smith was brought into custody on May 2nd of 2023, then posted cash bond on May 9th of 2023. She would have 8 days of credit from that time. She was then brought in on a warrant. I believe that was served and executed on January 31st of 2024. I then note here that bond was posted on February 5th of 2024, making for 6 days. Lastly, she has the current period of incarceration that she's been serving from May 26th of this year up until today's date, which would be, by my math, 69 days. So all told, by today's date, she would have 83 days of credit. I've relayed and discussed this with the state, and I believe that is the party's stipulation.
Yes.
Okay, thank you. And it's my understanding that Josie is still on supervision from the latest Minnesota conviction from June?
I believe so, Your Honor.
At least that's what the PSI is stating, and no one corrected me. All right, thank you. Argument and sentencing recommendation, please.
Thank you, Your Honor. I think certainly when we look at this situation, it is quite serious. It would be quite serious if it was a first-time offense. It is certainly serious as it is now. It involves a high-speed chase with law enforcement over several miles, at which point several items were thrown out of the window. It is serious. In discussing this case with her, Your Honor, and discussing this sentencing, it's been very clear, been made very clear to me that she understands that this is the last stop. There are no further chances that are going to be coming after this. Her record is quite long. It involves serious offenses. It involves offenses of a repeated like nature. As a member of the Mille Lacs Band in Minnesota, Your Honor, Ms. Smith is, again, in somewhat of a lucky position. She has access through her connection with that community to resources that frankly make the resources that someone else in that community pale in consideration. There's simply more funding, more programming that's available for her as a member of that tribe. The situation overall, Your Honor, looking at the reason why Ms. Smith keeps on coming before the court, the reason why she keeps having these issues in adjusting to supervision is by and large from an inability to address and move forward from an issue of substances with narcotics. While there is certainly programming available in the state prison system, Your Honor, it, I would say, pales in comparison to what is available and accessible to Ms. Smith when outside of custody. I'd also note that, frankly, in looking at Ms. Smith's history, looking at her connections to this area, to Burnett County in particular, what I have noted and noticed is that she is by and large a resident of the state of Minnesota. She has connections in that state. That is where her support network is located. That is where she has built her life, so to speak. I think creating a connection here with Wisconsin, Your Honor, would perhaps be a mistake, given that she has built up this connection, this relationship with her home state, such that presumably the ability to access the resources that she does need to address would simply be much more straightforward. So I think looking at the situation overall, Your Honor, while I do understand the hesitation regarding the history here and the severity of the offenses to probation, a good candidate because of these underlying needs, because of the fact that she has this clear issue, I would say, with addressing and maintaining her sobriety and proceeding down for recovery. So based on that, Your Honor, what I'm asking the court to do is to sentence Ms. Smith to a period of incarceration in the jail for 110 days, with eligibility for good time, on both counts here, concurrent with each other, consecutive to any other sentence that she may be serving.
Dear Judge Mogen, I'd like to start off by saying how sorry I am for my part in taking so long to realize how much time it's taken to get this case settled. I realized that I've made so many mistakes that I cannot change, but learn from it. I've been so hard on myself, and I know that just because of my past doesn't mean it's too late to change my future. I have so much to live for and do with myself instead of repeating past behaviors. I've learned that no one will or would judge me if I have to ask for help. I've always thought about others. People treated me different if they saw or knew that I needed help. But truth be told, it shouldn't matter to them because they don't know my whole story. And it doesn't matter what they think. I struggle and I struggle, but knowing or by thinking I know how to help myself, I didn't. I know now that maybe it's better if I get help from someone professional, or just maybe I can have the chance to get a better outcome. I've had some time to think of a plan for when I get out. I have plenty of resources and structure and people to stand by me and help me get through this that I didn't realize I had, and I don't have to go through this alone. I also understand that this is a serious and take full accountability for my actions. I didn't intend on hurting anyone, but by my actions, I do see now that I could have, anyone including myself could have been seriously hurt. I don't like knowing that I was the person putting others in danger. I hope you know that I'm really sorry for my actions in putting the police officers and myself in danger. I've learned a lesson that by the path I was going down would not end well for me, and that it's not too late to take a better one. As soon as I get out, I also plan on seeking help for my mental health. For my depression, I plan on seeing if there are medications that can help with my mental health. I know that things like medications take time to start working, but I like to start somewhere. I made a few phone calls to get into a program called the Endangered provides.
You just repeat that, please, and very slowly, because I'm not sure if I'm hearing it correctly, and my court reporter does need to make sure she understands as well.
Endangered. It's spelled A-N-J.
I have it. It's a double A too. I'll tell
Okay.
the court reporter how to spell it.
Okay, sorry. It provides sober living, work options, treatment options, and helps with college options. All that can help with my journey on recovery that will be beneficial for me. I'm planning on getting a Rule 25 as soon as I'm released. If I have to cut people out of my life that aren't fit for my journey, then I'm willing to do so. I just want to do right, and I want to prove to myself that I can do it.
I have reviewed the pre-sentence investigation report and the sentencing memorandum that has been provided by the defense. I have been struggling with this case, Josie, simply because you had your initial case, the 22 CF 120 case, which was serious enough. And then a year and some down the road is when you engaged in this conduct, very serious, dangerous conduct. And you received all of these charges, 10 actually, 8 felonies and 2 misdemeanors from the conduct on May 1st, 2023. The most frustrating part about your case, Josie, not only that you engaged in this kind of conduct to begin with, but there's those underlying issues that the court and other parties can understand, the substance abuse, okay? But the most frustrating part is how you would come to court, then you abscond and go away for a long period of time. Then you'd come back and say, Judge, I'm going to be better. I want to work this out. And then you'd disappear again. And then you'd come back and say, Judge, but really this time I really want to. And then you'd go and you'd disappear again. And we're dealing with a 2022 case where it initially started, and the 2023 case, we're dealing with cases that are 4 years, 4 years old that should have been resolved a long time ago. They were way back in the beginning. It's just that something would happen and you would flee, or you'd go abscond and you go engage in this other kind of behavior. Lucky for you, you didn't rack up a whole another sheet of crimes. I mean, there's a lot in there from the time that you were charged with our cases. But hopefully you're on your path to figuring it out. Because if you don't, with all of the things that are going on, Josie, both what you're displaying outwardly, but most importantly, what you're feeling and going through inwardly, it's going to destroy you. You have to work through those, and you have to start with going to the healing center, working through your traumas, discussing what you are experiencing and feeling today as Josie, all right? And that kind of situation before you can change yourself. And you did hit the hammer right on the nail when you were stating that, you know, maybe I can change the people that I hang around with, and I probably should. Because Josie, you have to change your habits and the things that you do, and you have to change your associates, the people that you hang out with, in order so you can change yourself. You have to be able to do that. That's where you start, changing your habits and the things you do, and changing the people that you give yourself to, you give your time to, your energy to. That's the only way you're going to significantly improve your life. And if you don't modify and make those changes, I hate to see where you're going to be in 5 or 10 years. I hate to see that. The court has to look at the seriousness of the allegations, the nature and gravity of the offenses here. And the court looks at all of the charges that were dismissed and read in, including the charges that you were convicted of, and to see whether or not there's an aggravation there. And there is, with all of these felonies and all of these serious crimes and the conduct that you engaged in, it does aggravate it. I have to look at your character, your past criminal record. I have to look at needs for your rehabilitation and protection of the public. And as Mr. Schmidt touched on, I have to look at this thing called deterrence. So what sentence is going to finally deter Josie from continuing down this path? And what sentence is going to deter others from doing similar things? Because if the court were to look at a lesser sentence, a smaller sentence than what's recommended here, well, let's say a very small sentence. We'll start at the short end of what defense argued, 110 days, concurrent with each other, but consecutive with any other sentence. If the court were to look at a sentence structure that is that small with the actions here, it would unduly depreciate the seriousness of the offense, and it would not deter others from doing this. Because if we look at this, the charges alone that you pled guilty to and you're convicted of, that was extremely serious. Speeding down a roadway, a highway in Burnett County, and throwing things out of the car to try and evade and flee the officers. Where Mr. Schmidt made a very good point that if something were to be thrown out of the vehicle and were to hit the officer's car going at a high rate of speed, anything could happen. The officer could swerve and hit a pedestrian, could hit a different vehicle, could hit a house. The officer could die. Innocent people could have died because of your actions and conduct that day. You are at this age where your brain is finally starting to fully develop, and you're starting to be able to think like an adult. You have to now start thinking clearly. Is this where you want to be in 2 more years, Josie?
No, I
you don't. Is this where you want to be in 5 years or 10 years? Or is this where you want to see your friends or your family in something in a chair right there,
No, I
waiting
don't.
to determine if you're going to go to prison?
No,
But you are letting your internal demons destroy you. You are. I do understand you've had a lot of trauma in your life. I've read it in the black and white, and I've heard some from you throughout these years. You can't let the trauma continue to dictate and to control your life. You have to do that. But I do think it is serious enough to sentence you to 1 year of jail, of county jail. Okay, 1 year. There will not be any ability to have the electronic monitor because I don't trust you. Sorry, I don't. And you're shaking your head up and down like you,
I
it's
understand.
fair, right?
I understand.
So 1 year in the county jail, that gives you enough time to sit and to think and to figure it out. And it is consecutive to all other sentences. And it is each charge, each count has 1 year of jail concurrent to each other, but consecutive to any other sentence that you would be sitting, okay? $518 in fines and fees. I am also going to do a punishment factor on the financial end of it. $1,982 for each count in a fine. Because you failed to come to court, you failed to take care of this and handle this, and you missed court and absconded and were in custody somewhere else when you shouldn't have been, and the court did not even have to allow you to appear by video. But I believed you, Josie, when you said you want to make these changes and you want to do better. I believe you. But you have to grasp that hard and you have to take control and ownership of it. I can't want it for you more than you do. Mr. Felisky can't. No one in this courtroom can want it more than you because you're the one who has to do it. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. No use or possession of a firearm for life. No voting in any election until your civil rights are restored. That does not include tribal elections. You have to speak with your tribe if you are having an election, whether or not they would permit you to continue to vote. No contact with Burnett. Don't come to Burnett, okay? Because if you're not doing well, I don't want to see you again.
I don't plan on.
But I want to know if you're doing well, okay?